All right, we're ready to go to this one in session.
Good morning, please be seated. This is the time and date set for oral argument in CV21-0029, No Worries Rooter versus Marlin Mechanical. These proceedings will be video as well as audio recorded. We ask that you identify yourself and who you represent before you begin your argument. These proceedings will also be live streamed. We have people watching, so speak clearly into the microphone. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal. We ask that you argue from the podiums instead of the middle so that we maintain a germ barrier. We have read the briefs. We have discussed this case in conference. We are familiar with the facts. Please take that into account when you proceed. At this point, counsel, when you're ready.
Thank you, Your Honors. This is Ross Meyer on behalf of No Worries Rooter Appellants of Willinchek and Bartness. May it please the Court, thank you, Your Honors, for hearing this oral argument and the review you have done to date. This case is here on a statute of limitations issue that, if it were any other cause of action, would not be here. From any other cause of action, it would be when the plaintiff is damaged, when they know of their damage, or should reasonably know of their damage, and the discovery rule would be applied. But when we look at defamation and claims similarly situated, we apply a publication rule. And the publication rule makes sense historically. Historically, defamation primarily came from oral statements or written newspapers or magazine articles. Those are daily publications. They're not kept up and continually published every single day with the same statement. They're kept on microfilm, but that's not in the public being readily accessible the same as the original publication.
Well, but aren't they now online? Can't you go to newspapers.com and find stuff going back to, well before I was born?
Of course. Now you can. That's exactly right. But when this rule was created, that was not the case.
But has the restatement second changed in light of this, or are there other, authorities that have sought to say that, the single publication rule really doesn't apply anymore in light of this?
No, Your Honor.
Okay.
That is not the case, and that's what I'm asking this court to look at and analyze, that when the single publication rule for defamation claims was enacted, it made sense. And it made sense because if you didn't learn of any damages at that point, you probably weren't damaged by the statement. If there weren't a second story or a second repeat or something that happened, you're probably not damaged. And so there's no claim initially. But if that statement is made, and of course cut me off if you have something.
Well, so you're saying that at least, in this case, anything that may have existed as a result of the publication in 2011 didn't cause any damage?
Maybe not. I mean, but that's not the question. But also,
but that's your argument. You're saying, I get to wait until I find out whether I've been damaged, and really isn't it just the publication that creates the damage, even if it's, a de minimis $1 damage?
So the airing of the Dateline video on NBC, yes, that could have caused damages. What happened, though, is my clients said, you know what, I'm going to dig down and build my business despite this. It's not a recurring problem. It is what it is, and I'm going to get through it. Then you fast forward years to the future, our technology has even changed since 2010-11 with Yelp, Google, Facebook posts, different ways that people do business has changed. And reviews and comments are a big part of small and local businesses. When that video is reposted on a different forum, and 5, 6, 7 years have passed, even if you want to get into the, should my client have been checking on Marlin Mechanical because 7 years ago they were part of this video and involved in the filming, I think that's an unreasonable requirement, because the cases that go into whether you should have known because this person had done something similar before are in the context of people that you have interaction with. They're coworkers that you knew bad-mouthed you to someone, their neighbors, their ex-spouses. Here, this is someone that was involved in a filming that my client went to a house of a customer one time and then 7 years later post a video. Excuse me.
Counsel, let me ask you, your client was aware of the video in 2011, correct?
Was aware of the NBC
Publication of it.
post. And
Got it. And the reason why I ask that is, we're being asked in the statute of limitations, setting aside for a minute the application of the discovery rule, but that's a legislative act expressing a public policy of the state that defamation claims need to be moved along very quickly, pressed quickly, and then presumably addressed quickly. And that's a policy that 2 other branches of the government have directed for us to accept. The discovery rule is, when it applies, is a common law overlay of a statutory directive. So there's a question, I suppose, about its legitimacy in that respect. But particularly where, as far as I know, other than a notice of claim or something like that, 1 year is the shortest limitation period that the legislature has set down. Isn't that a tell that folks down the street are saying these things, you need to move fast?
Of course, and that is accurate, but there's 2 criteria there. One, the cause of action doesn't accrue until you actually are damaged.
And let me ask you about that. How in the prima facie elements of defamation, damage is kind of a fuzzy concept. It is not like common law negligence, where it's one of the 4 prima facie elements, and if somebody hits your car, you know what the damage is. But can't you proceed with the defamation claim even if you can show no demonstrated loss of business? I mean, it's unlike any other kind of common law claim when it comes to damages.
So you're saying basically flip my contention around, and you can still proceed even if you don't have quantifiable damages then, because they're murky and a jury could say you are damaged.
And it's part of a broader, yes, but it's part of it's part of a broader question that aren't there, just given the nature of a defamation claim, aren't there really good reasons why the discovery rule, which is based on when you find that you're damaged, shouldn't apply?
I don't think so, and where I'm going with that is, if you're not damaged, because it is such a murky, quantifiable area, I mean, you have to have experts show what your damage is. It's a defendant would simply move for summary judgment saying you're not damaged, and there have been similar cases where things have changed in the past 20 years with evolving of society. Sure. And so one of those cases, it's out of New York, and the example is a plaintiff was called a homosexual slur, and so they filed an action, and I forget which New Yorker court, I don't think it was their Court of Appeals, but I think it was their appellate court, said, look, that is no longer a defamatory statement because homosexuality is generally accepted in our society, and it doesn't mean the same thing it did 50 years ago.
Right.
And so, but that's directly to your point, albeit a little roundabout way, that damages, a defendant can move and say, there's no damages here.
But
And-
is that genuinely a realistic option for a defamation claim? I get for any number of claims, fraud on the market in a securities context, sure. But with defamation, because it is so hard to identify what could and could not be damaged, and setting aside for a minute nominal damages, right? Is that really a viable sort of defense on summary judgment with respect to defamation claims?
So I would akin it to a loss of business expectancy. It's similarly vague. It's difficult to identify. And in those cases, defendants do say, look, you didn't have damages. But conversely, you might not lose a customer right when whatever action happened and that business expectancy. It might take 2 years for that contract to renew, and when that contract doesn't renew, that's your damage and your starting point, and then you go from there.
And I understand, but that's sort of a nature of a tort like that.
Sure.
Or defamation, if somebody says something that's actionable, and let's not get into public figure, all
Right.
the constitutionalized aspects of a defamation claim, but somebody said something that's actionable and I feel bad. Isn't that enough to get beyond summary judgment?
And I feel bad.
It hurt me. How about that?
Well, it's actionable. How you feel, I don't think is important, so long as it's actionable.
True, but that's my point. Under your example, someone said something, and you're hurt. And here in this case, what the lower court said is, hey, it doesn't matter that there are more posts, and I don't know if this is true, but I think it, and there's a lot of little science memes that apply, but there's more information on the internet than there are atoms in the galaxy. It is a crazy place.
There's a lot.
There's a lot, and you can go down rabbit holes at 2 a.m. that you didn't know existed. And it seems unreasonable to say that a plaintiff has 1 year to search the entire internet, and they should be searching the internet for their name, their business name. But with a name like Jose Quesada and Daryl Quesada and No Worries Rooter, there's a lot of posts containing that search information. And so that to me seems like an unreasonable standard to say, we're not going to apply the discovery rule in the general sense. And this court in Division 2 have applied it in an interesting way. And opposing counsel and I were talking before this, and he said it's kind of the same thing. The discovery rule is the same thing. It's just said in a more a different way. The discovery rule is the same as a breach of contract action. It's just said to apply to defamation by saying, hey, it's the publication date, or it's if it was hidden. And that hidden language, too hasn't evolved to where we are today. That's still stuck in the 1970s. And I think in my opening brief, I know in the lower court I cited it, but I think in my opening brief I touched on, the credit history or credit report statutory items and how, that was pretty confidential things, and there's a lot of reports and information there, but it was accessible. And I think that's the same here. There's a lot of information. It's hard to find things, but it is accessible. And our appellate courts have said that credit reports like that would be private and confidential in a way to apply the discovery rule.
Counsel, do you have a case from any jurisdiction that has adopted what you're asking this court to adopt here today?
Okay, so that is a great question. The quick answer is no. There is a case that is almost gets there, but for the facts. And that case, I think I cited it, I might not have it. It was a federal case out of Texas. And basically what happened there was, I believe it was an Asian plaintiff and defendant, but basically there was a large Facebook group and someone was posting defamatory statements. And the court said, we're not going to apply the discovery rule because this person was a part of the group. And it was like 10,000 people, and there were a lot of posts. But they said, you were part of the group, so you should have known or been able to see it or know someone that would have seen it and seen the comments on it. And so that case, I think that court would have done something differently if they weren't connected. And the one example I want to give, so that's the answer to your question, is I looked, I couldn't find it, and I think those courts are wrong. But I have not seen those exact facts also as well. But the example I want to give, and this is where the application is really odd. With privacy settings and different functions, someone could go make an absolutely horrendous defaming statement that's just crushes someone, say on January 1st of year one, but put their privacy settings to completely private, they have no friends, no connections, and then on January 2nd of year two, change and make everything public. You don't have to be connected to them to see it or comment on it.
So wouldn't the latter qualify as the date of publication if their privacy settings were so severe that no one else had access to it up until that date?
I would agree with you, but the problem is when the plaintiff is damaged, how are they to know that those privacy settings were changed or even modified, or even something weird as that would happen, because a defendant would just file and say, it was published on this date, look, here's the post, and they filed it over a year after. You wouldn't even be able to get to the discovery to find out if the privacy settings were changed, because on its face, the discovery rule doesn't apply and it's public at that time.
And counsel, I understand your point, and that hypo is in your opening brief, but that's not the facts of this case.
I agree with that. But what is the facts of the case is that someone who was not in the same business, was not a competitor of my clients, they were in commercial plumbing, was posting a video on their Facebook page that was then used and customers saw it and chose not to use our business. And when my clients learned the video was posted and those text messages were provided in the response, they immediately found out and learned what was happening, and then searched the comments, did reasonable diligence, and saw the Facebook link to what happened and connected the dots.
And I want to get back to the hypothetical, because it was in your opening brief, and what you talk about is the privacy settings and the date of publication. But in discovery, if no one saw it until the date the privacy settings were changed, you would have an argument through discovery that you could be able to access that, wouldn't you? When you say publish, it means supplying it to other people. It doesn't mean necessarily putting it in a private cubbyhole where nobody sees it. That's kind of the distinction I'm drawing.
I suppose, but I would make the reference to if a newspaper was published in a small town and, the small town said, oh, our readers aren't getting this newspaper delivered today because there's a snowstorm, but they published it, and then years later that goes on microfilm on the internet, then that would be the publication date. But under your hypothetical, you're saying because no one received it and read it from the newspaper, that actual publication date wasn't the real publication date. I think we would say it was the publication
I think
date.
there's an argument to be made there, but again, that's not what we have here.
I'm running out of time, and so I'll save a little bit, but I really do love this issue, and I love that you have each spent so much time on this. The last thing I want to say that's slightly related is I don't think a motion to dismiss can be converted to a motion for summary judgment by the opposition. It might be able to, and we also talked about that, and I could be completely wrong, but I think my argument is right in that it has to be the actual motion to dismiss that contains the outside documents from the complaint, and I will reserve 25 seconds.
Thank you, counsel. When you are ready.
May it please the court, my name is Paul Kular. I represent the defendants in this case, specifically Mark Gibblehouse and Jane Doe Gibblehouse, as well as Marlin Mechanical Corporation. I know you've read the briefs and obviously studied up on the file, so I think where I want to start is with some of the issues that were raised while my counsel was presenting. You had asked counsel if there was any case in the entire state that he could find that adopts the issue or his position, and I think that's a great question. The restatement talks about there being a modern trend, and the modern trend being that the date of publication is the date the statute runs, unless we have a situation where the defamatory statement was concealed or hidden. Confidential is a word used. Inherently secretive is another word used. So this is a modern trend that we follow here in Arizona. Counsel also mentioned the fact that that publication rule maybe made sense in the past because these newspaper distributions, and then maybe the newspaper would be thrown away, so you would maybe not be damaged. My point on that is I think it actually makes more sense today because we have the internet. We have more exposure. We're talking about the World Wide Web where you can get anything you want at the click of a button, which is exactly what happened here. The plaintiffs were able to access the alleged defamatory Facebook post through the click of a button. Facebook's a free website, completely accessible to anybody. You don't have to pay for it like you have to pay for a credit report. So we're talking about a situation where there's nothing inherently secretive or confidential about this. Counsel made a
Would you agree with him if the facts were the ones posed in the hypothetical behind a small group of friends who graduated from a small high school, in 1960, and there are exactly 10 or 12 left. And then a year later, they opened it up to say that, a former colleague is, whatever scurrilous thing you might want to say about a person, regardless of, that's the date of publication, if you could get there. Would that be actionable at that point in time, or would, you argue they are still precluded because it was published amongst the 12 people?
It's a great question. So I think it'd be actionable potentially for two reasons. We talked about, and you guys brought it up, being injured, feeling hurt. I mean, that's actionable. So that would arguably be actionable at the time that it was discovered. But I think what you're saying, if it was a year and a day later, and my position on that is, how is that not hidden or concealed? I mean, that's you apply the discovery rule to that. So I think there's that opportunity there to bring a colorable defamation claim by making that argument.
So it would be factually dependent if one could convince the trial court to allow brief discovery, or if the court in fact had seen the motion to dismiss, seen the additional information that was provided by the plaintiffs, as I understand it, and then they could have said, well, Your Honor, we under 54B, we would like to take limited amount of discovery to figure out whether it was hidden behind a wall and when it was actually published to the whole world.
I think you nailed it. And when we file our motion to dismiss, plaintiffs saying that the conversion rule doesn't apply if the plaintiff attaches anything, stuff to their response brief, that doesn't make sense to me. I mean, that's giving them an advantage of converting anything to an MSJ, but to your point, that would be a good idea to do in that situation. Let's convert this to an MSJ. Let's get Rule 56D relief, which wasn't requested here, so my position is that was waived. Let's get that relief so that we can do the discovery and, get to the bottom of this. But that's not what happened here, as we all know. The plaintiffs learned about, the statute of limitations in this case worked exactly like it was supposed to. In the first year, they knew about the alleged defamatory statements, and what did they do? They didn't do anything. 5 months, almost 5 months, passed. They had 5 months to file their lawsuit, and they didn't do that. So, and again, I don't know the reasons why. I know it was argued at the trial court level. The other point that Judge Thuma made was the issue about getting to the court fast. That's a great point, and that supports the public policy of the statute of limitations. In Clark, the court reaffirmed the policy considerations behind statute of limitations, including discouraging the presentation of stale claims and encouraging diligence in bringing actions. So I think you're absolutely right about that. The issue about and again, this gets back a little bit to what Judge Portley said, but the issue about the privacy settings, that doesn't resonate with me, because if you're hiding something, if you're concealing something, that's exactly what the discovery rule is there for.
Counsel, with respect to technology, and technology has changed things. How exactly is one of the things we're asked to decide. But what if instead postings were behind a paywall, even a trivial paywall, X entity that costs 99 cents a month, but you have to have the password to access it, you have to pay a little bit of money. Is that being hidden or secreted or concealed or not?
I'm sorry to interrupt. I think so, potentially, because now we have a situation that's similar to credit report. It's probably worse than that, because with a credit report, it's not being reported to anyone unless you ask it to be reported. With the example you gave, people may already see it. Credit report has to be paid for. That sounds like you'd have to pay a nominal fee for your example. So I think that is a situation where it could be considered hidden or concealed.
And let me alter my hypo just a little bit more. So you still have to have a password and a username, right? So it's not publicly available, but no money changes hands on a monthly basis. Is that still hidden or concealed?
If you can't access information on a website where there's alleged defamatory material that is getting to people and you don't know about it, and the only way you can know about it is putting in a username and password, I think it's getting a little bit fuzzier, because you can do that.
Well, and by definition, these hypotheticals are intended to be that way. But.
And I think it does get a little bit fuzzier because you'd have to put in the username and password, but is the username and password there because they don't want you to see the defamatory material? I'm not sure exactly what website we're talking about or what the situation may be.
It's hypothetical, right. Honestly.
But yeah, I think it does become a little bit more murky, yeah.
It could be as simple as, local TMZ on plumbers.
Right.
Or something, where you do have to put, and there may be people who are reluctant to put in their email and create a password, but they do know that something popped up and they want to see it. And so I suspect whether the statute runs from the date of publication might really then turn on, how much of the privacy are you willing to find out about, anything scurrilously that was said about you.
And I think there's other things that we need to consider, which is the circumstances that we have here, which is this video at issue came out in 2011. It was then posted somewhere else, I believe in 2012, if I'm not mistaken, and then again in 2016, and then 2019 is when they finally decided to do something about it. We're talking about the single publication rule here, which is, again, been adopted throughout the country, is my understanding. If it hasn't been adopted completely, which nothing ever is, my understanding is it's the majority rule. So for
Would
that
this
reason,
be considered a republication of the original?
Your Honor,
Or what else would have to occur if it wasn't, and it's still just, a republication is, I'm thinking of any sort of things that, you learn on the schoolyard, and you then, go into class and you tell your friends.
sure. I don't believe it's a republication under my understanding of the republication rule. I mean, if you just take something from 2011, a video, and you post it on your website, it's the exact same thing. Now, if you're saying, it's new material or something to distinguish it for something else, emergency alert or something to change the context of the video, now we're talking about a possible republication.
When
I
we
think.
talk about a video, and we talk about publication on the television versus publication on the internet, do you see any distinction between that kind of publication? And are you aware of any court that has made that distinction?
I haven't done that research to give you a clear answer on that. When I think about republication and the research that I've done on that issue, it's if you don't change the context of the video, the way the presentation is made, I mean, if you're just taking one thing and republishing it somewhere else, like again, this occurred in 2000, I think again, I believe it was 2012, 2015, 2016. So I mean, this went on for several years, and nothing was done about it, but that's besides the point. I think there has to be more than just simply posting it somewhere else. Media outlets, newspapers post the same articles over and over and over again. Unless they change the substance of it, I don't think you have a republication. But that's coming from, that's my point of view. I mean, that would be an interesting issue to brief. And fortunately, I didn't have to do that here because I wasn't.
Just musing.
Yeah, absolutely, yeah. If I could, I'd like to turn to the issue of the conversion rule, just briefly. I don't think I'll spend 8 minutes on it, but with respect to the conversion rule, I think if you don't apply it the way that the court did, again, like I said before, I think the plaintiff's at an advantage. The plaintiff can convert a motion to dismiss would potentially, I mean, it would, if they could just post stuff and it's not going to be converted, I mean, how would you win a motion to dismiss? It would just be so difficult because they could put anything they want into their response, and if it's not being converted, it's like you're at such a disadvantage. And you don't want everything as a defendant to go from a motion to dismiss to a motion for summary judgment. But the court did point out, in the court's order, the trial court, did point out that there's conclusory statements, and so they looked, in my opinion, the trial court looked at really everything. I mean, I understand that the trial court applied the conversion rule, and I think it was correctly applied for the reasons I've stated, and the trial court also went through the exceptions. One of the exceptions being, did we have to rely on any of the information you attached to your response to reach our decision? Was it a public record? Was it attached to your complaint? Was it central to the issue? The court went through those, went through that analysis and determined it was not central to the issues. The whole purpose of attaching the exhibits that were attached by my counsel to their response was to defeat the motion to dismiss. It had nothing to do with the underlying claim. Like, what did this Exhibit 2, which was the settlement demand to my client, have to do with their defamation claim? It had everything to do with, look at, we were being diligent, look at, we made this demand, and then attaching all the communications with the insurance carriers. That was all about, oh, they're leading us on. You know, they're being dilatory. And we think the statute of limitations should be told because, again, they let us on, but they were just doing the coverage. They were just doing the coverage analysis, which every insurance company does. Again, the plaintiffs had 5 months. I mean, the statute of limitations, I can't emphasize this enough. I mean, the statute of limitations worked exactly like you'd want it to work, like the legislature had hoped it would work. They had 5 months to file their lawsuit, and they didn't do it in a timely manner. Unless your honors have any questions, I have about 6 minutes to go, and I feel comfortable stopping. All right. Thank you.
Okay, I have 28 seconds. I wanted to make a couple comments. on your example of the hidden paywall and password wall, I think that would be the exact same thing as having to add someone on Facebook and whether it's approved or not. And then I have 5 other things. To your comment, I'm going to stop, but I think there's just 2 things. Dubé v. Likens was a case where it was tangentially similar, but not with the internet. And then also, it would be an interesting law review article to have someone compare why statutes of limitations are imposed so strictly, whereas the RFA deadlines of missing them are not as imposed, and the damages.
Thank you, counsel. Well, I think you
You've
both,
got yourself a project.
yes.
You've got yourself a project.
I thank you both for your arguments here today. Interesting topic. We will take your matter under advisement. We will issue a written ruling in due course. Thank you, gentlemen.
Appreciate it, Your Honor. Thank you.
Thank you, Your Honor.
Appreciate you all.
Thank you.
Are we off the record? Are we off?
Mics are still hot.
Oh, the mics are hot? Okay. I was just going to say thank you again. It's my first opportunity to argue, and I enjoyed it. Thank you.